it was a little disingenuous when we had certain proponents going and suggesting that the warrant requirements that we were advocating for would somehow put lives at risk. I think that members of the House that were working on this, they were very thoughtful. Representative Jim Jordan, Representative Warren Davidson, Representative Zoe Lofgren, Representative Mila Jayapal. These people were very dedicated towards making sure that that exact kind of situation didn't happen. There were carve-outs in that bill to go and deal with exigency, that emergency situation that you're describing there. So the notion that somehow requiring a warrant for normal order kind of investigations that the FBI is doing, it's just a little ludicrous to me, because again, then that's not exigency anymore. That's just you trying to have a convenience. You don't want to have to deal with the paperwork that's associated with a warrant or something. And I'm sorry, but the job here is not to make it easy for you as law enforcement all the time. It's about having a system.
Americans are capable of achieving extraordinary things when they have the freedom and opportunity to do so. This is American Potential. And here's your host, Jeff Crank.
All right, well, thanks for joining us for another episode of American Potential. Appreciate you being with us. Look, how well do you know the Bill of Rights? Which amendment is this? The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Well, that's the Fourth Amendment, and it refers to no unreasonable searches and seizures. So how are parts of the government allowed to violate this amendment when it comes to your private information? Now, the Foreign Intelligence Surveillance Act of 1978, or FISA, established a framework for the surveillance and collection of foreign intelligence information between foreign powers and agents of foreign powers suspected of espionage or terrorism. And it created the Foreign Intelligence Surveillance Court, the FISA Court, to oversee and approve requests for surveillance warrants, ensuring a balance between national security needs and individual privacy rights. So are Americans having their Fourth Amendment rights violated through FISA? I want to welcome James Czerniawski, who is the Senior Policy Analyst of Technology and Innovation for Americans for Prosperity. James, thanks for being with us.
Thanks for having me.
Yeah. So, okay, let's talk about the Fourth Amendment. And give us a little history of FISA and why it was passed.
Yeah, I think you kind of hit the nail on the head there in that intro, where it's tied back to the 1970s with the investigations that were held by the famous Church Committee, which was looking at how the government was being used to spy on Americans, which was even going back to like Martin Luther King Jr. So this is actually a very deeply rooted thing in bipartisan kind of causes. You saw it getting weaponized against Martin Luther King Jr. and Watergate. And as an outgrowth of that, we saw the formation of FISA as a way of having that system in place to go and respect Americans' constitutional rights. Unfortunately, that does not always seem to go and pan out as we're looking over the years. And fast forward to 9/11. This was an excuse to go and ratchet up those surveillance authorities, because you had this horrific event happen on 9/11 that cost 3,000 Americans their lives. I lived in New York at the time. I remember how scary that day was. And that particular incident resulted in the government going and expanding its powers with the Patriot Act quite drastically, where they were going and capturing the communications of Americans in the name of, protecting us against domestic terrorism here at home, or terrorism more broadly speaking, I should say. And then it got discovered. And in 2007, 2008, we had the Congress go and pass the Foreign Intelligence Surveillance Amendments Act, which gave us Section 702, as well as a whole bunch of other kinds of spying powers codified into law that were kind of discovered as a result of everything that transpired underneath the Patriot Act post 9/11. So that brought some much needed, oversight, accountability from Congress into the executive branch. Unfortunately, once again, then what we saw happen in the years since then, the 15 years since that particular legislation was passed, was just a litany of countless examples where the government abused these powers that were meant to go and spy on foreigners that could present a threat to the United States, but they were actually leveraging it to go and spy on Americans. And that's really bad. It's really untenable. And what ultimately happens when you do things like that is it undermines the public's trust in the very institutions that are responsible for keeping them safe. And this is something where we've seen increasingly in this most recent Congress, a really strong focus on, the weaponization of the government to go and spy on Donald Trump's campaign, which happened underneath Title I of FISA. And that certainly brought a lot of conservatives to be more cognizant and aware of how government power can be leveraged to go and intrude on their daily lives in ways that they might not otherwise think, in a way that was touching them more directly. So I think that there's a lot of different components of FISA here. It's actually a lot more bipartisan than people realize in terms of the kinds of parties that are interested in this. And, unfortunately, we had things kind of play out a little bit differently when it was up in Congress. But we had some really good conversations as a result of that, and having people really have to face the real dark kind of nature of what happens with FISA, more broadly speaking.
So I think most Americans look at what happened on September 11th and agree that, there was sort of a failing there. There was missed intelligence. But they also, I think most Americans also understand that, the Fourth Amendment, the need to protect, our constitutional and our civil rights as Americans. And of course, the Constitution and the Bill of Rights is set up so that it prevents government from infringing upon those rights. And that's exactly what can happen under abuses under this system. Explain a system or maybe the way that this whole system could be fixed to where you could both gather necessary intelligence from foreign agents or foreign governments while also respecting the Fourth Amendment rights of Americans.
Yeah, we thought that we were being quite reasonable when we were having conversations with members of Congress as well as the administration. I remember having a meeting with the ODNI, the Office of the Director of National Intelligence, back in September of last year, where we kind of highlighted some of these key reforms here that we were looking to get accomplished. Number one, kind of as the outset of this podcast suggested, get a warrant, respect the Constitution, the Fourth Amendment. If you're not going to respect the Constitution and the rights that it affords to Americans, then really it's nothing more than a bunch of words printed on a piece of paper. And that's not really a tenable situation. People need to believe in these key institutions. And by having a warrant, it at least goes and introduces that intention of it to give an American due process rights underneath the laws of the land here. So we thought that was something that was very critical. We also thought that it was important to have some level of accountability for officials that were violating the law. One thing I think that was pretty consistent that we saw over the years with all the different litany of abuses was that they could go and flagrantly violate the law, and the accountability was just simply not there. Even in the instance with Carter Page and the Trump campaign, where they were spied on underneath Title I. That was, done where they lied on their affidavit to the FISA court, and that person's punishment was just getting a probation to the FISA court. Right. And that's not really good when you see people having this system getting weaponized in such a manner, and then the people who were perpetrating that not really being held accountable. So we were certainly pushing for more accountability there. And then by extension, too, from a due process standpoint, barring the government from being able to circumvent your Fourth Amendment rights simply by buying your data from like a data broker. This is a very common issue that we've seen happen both at the states and the federal level. The courts have said in the past that, if it's not in your own home, like when you're talking about the Fourth Amendment, we think about it in plain sight, what's in your home, particularity, all that. But the courts have been a little squishy on this in the past, where if it's data and it's being held by a third party, it's technically not yours. Therefore, the government doesn't have the same, obligations or interest to respect the Fourth Amendment in that sense, even though it's still, information that's pertaining to you, your activities, and how you're expressing yourself. the government was able to circumvent that by simply going and buying data from data brokers on you, right? So it was tackling the data broker loophole. It was sitting there focusing on having accountability for people that were violating the law, and also getting that warrant requirement, that due process. Those are some of the critical things that we were fighting for when it came up to this conversation most recently this year. Yeah.
What would you say to people? There are some members of Congress and others who make the argument that, they can't wait for a warrant. Some of this stuff is actionable. They have to gather it when it's there, or they are going to lose the ability to collect that information. In fact, they'll even argue that if that were the case, there are going to be lives that are lost because they can't gather certain intelligence while they're waiting to get a warrant. How would you respond to that?
Yeah, I think that it was a little disingenuous when we had certain proponents going and suggesting that the warrant requirements that we were advocating for would somehow put lives at risk. I think that members of the House that were working on this, they were very thoughtful. Representative Jim Jordan, Representative Warren Davidson, Representative Zoe Lofgren, Representative Pramila Jayapal. These people were very dedicated towards making sure that that exact kind of situation didn't happen. There were carve-outs in that bill to go and deal with exigency, that emergency situation that you're describing there. So the notion that somehow requiring a warrant for normal order kind of investigations that the FBI is doing, it's just a little ludicrous to me, because again, then that's not exigency anymore. That's just you trying to have a convenience. You don't want to have to deal with the paperwork that's associated with a warrant or something. And I'm sorry, but the job here is not to make it easy for you as law enforcement all the time. It's about having a system where you're following a set of rules, and it actually protects you to avoid some of these very outcomes that we've seen happen, whether it was spying on Trump's campaign, or going and spying on Black Lives Matter protesters, or spying on people who were present at the Capitol for January 6th. You name it. This power has been abused time and time and time again. And if we had some of these core basic kind of protections in there, we would have avoided, I think, many of these kinds of dramatic, exposés that got found out later on when the intelligence community basically got caught with its hands in the constitutional cookie jar, if you will.
Yeah. So you believe that there is a way to reauthorize this with protections that would allow the government to collect the necessary intelligence from foreign sources while still protecting the civil rights of Americans and having to go get a warrant, and still, have some exceptions and some timeliness issues there. So there is a balance that you think can be struck?
Absolutely. What we have always and consistently said whenever this conversation has come up is that having a national security and then also protecting your civil liberties, they're not mutually exclusive goals. Mm-hmm. They can be mutually reinforcing, because your national security gets undermined. As I was saying at the outset, it gets undermined if people don't believe in the very institutions that are responsible for keeping them safe. The FBI, the NSA, the CIA, our intelligence community, more broadly speaking, has hemorrhaged and undermined the public trust when every single time and time again, we get a new story about how they've gone and abused these powers to go and spy on Americans, or that they've gone and circumvented the Fourth Amendment requirements by simply buying up data on Americans. The FBI had a pilot program where they bought up geolocation data of Americans. And that's very disturbing, because again, what's the justification here? These are otherwise law-abiding American citizens. You have no reason to believe that they've done anything, not even suspicion of a crime.
Right.
And now all of a sudden you're spying on them. That is a serious affront to their civil liberties. So we have to be able to have a system in place that respects that national security interest, while also not just letting it be this nebulous thing that has an unlimited reach in terms of how far we're willing to take that argument in the name of, protecting us. We're going to go and give up a little bit of, we're going to go and give up our civil liberties in exchange for a little bit of security. You're going to end up with neither, right? As Thomas Jefferson would go and say. So I think that's the core fundamental issue here.
And what we're talking about here are the gathering of intelligence on American citizens. None of this would affect the gathering. I mean, there's no requirement to go gather a warrant for someone who is a terrorist outside and not an American citizen, a terrorist outside the United States who's calling someone, let's say, in the United States. This wouldn't. You're not suggesting we go obtain a warrant for that person, right?
Absolutely not, Jeff. That would be completely out of bounds in our view. It's about, making sure that because the way that data works, right, is that we don't necessarily store our data in one location. Our data flows are global in nature. So American data is not just here in the United States, but it's in Europe. It's crossing over all over, right? And now all of a sudden you can have incidental collection come up when, we're targeting a non-U.S. person with these surveillance tools. But in the process of doing so, we have incidentally collected a lot of information of communications of Americans. And what we're simply saying is that, hey, if you want to go and look at those communications of Americans, that's when the warrant has to kick in because, again, they are Americans. They are afforded the due process rights underneath the Constitution. They have not been, any indication to go and suggest that they are a criminal or they're going to go and commit a crime other than simply having maybe a very loose connection to the person that might have been targeted. And that could be completely benign. There's nothing to go and suggest always that there's any kind of strong link here between those two things happening. So that's why, again, when it comes to non-U.S. persons, we're not saying that you need a warrant there, but we are saying that when it comes to Americans, that yes, you need to respect the rule of law and the Constitution and get a warrant. People are entitled to that because you don't even know that you're the target of these kinds of surveillance queries until well after the fact, because it's done in that FISA court, which is out of the public eye. It's not as public.
Well, look how long it took Carter Page to figure out what happened to him, right? I mean, it was years later when all that was revealed.
Yeah, and that's the common problem here is that when we're looking at all this, it's all done in retrospect, right? So we're finding out all these violations or issues after the fact when the FISA court, goes and releases, its reports on the programs themselves, right? And most recently, when we're talking about 2021, 2022, you had the FBI conducting over 3 million warrantless searches of Americans' communications. They did some little tweaks in terms of how they were counting the numbers, et cetera. And that number dropped to still very staggering 200 some odd thousand searches in 2023. So it's still very problematic. Let's not pretend that, there's some kind of sliding scale here where it's all of a sudden okay if it's just like 100 or something. Like, we're not talking about some, offhanded use cases here. We're talking about hundreds of thousands of queries of Americans' communications. And that's why it's just not tenable. You can't just go and have that be the standard.
Yeah. Well, all right, let's talk about Section 702. Now, that was in the news, certainly. When was this section introduced and what does it do?
Yeah, so Section 702 was part of the Foreign Intelligence Surveillance Amendments Act back in 2008. That's when that got added into the Foreign Intelligence Surveillance Act, more broadly speaking. And this program allowed for the NSA, the FBI, all of our intelligence community to go and collect the communications of non-U.S. persons in the furtherance of its investigations for potential terrorist threats against the United States. And like I was just saying before, the issue ends up being with that program that because of the way of how data works, you're going to incidentally collect the communications of Americans in that process, which means that, again, you have hundreds of thousands of examples now of instances, rather, I should say, where Americans' communications have gotten scooped up in this process by leveraging these powers, and the American government has used it to spy on them for one reason or another. Like I said, you had it where it was the Black Lives Matter protests in 2020, people who were present at the Capitol for January 6th. You had it getting used against a sitting member of Congress in Representative Darren LaHood, we believe. You had it getting used against a state judge. The list goes on, Jeff. And again, this is supposed to be focused externally to foreign, non-U.S. persons. And yet we're seeing time and time again all these incidents showing up that are involving U.S. persons. And that's not a good situation to be. This is about the Foreign Intelligence Surveillance Act. We want to protect our nation. But again, once it comes internal, and this is an administration that has certainly spent a good amount of time talking about how the greatest threat that this country faces is domestic terrorism. In that instance, it makes it all that much more important that we are going and abiding by the Constitution as these intelligence agencies start turning their gaze inward into the country, right? That's, I think, what the fundamental issue here ultimately becomes as we're looking forward.
Yeah. So how do people, if it's meant for communications between a foreign person outside the United States and someone inside the United States, how is it being used for communications between two people in the United States just being abused?
Yeah, I mean, I think that that's the kind of risk that you run happening here ultimately. Right. And this is actually...
Has that happened, James? Has that happened?
Well, again, so because it's collecting the data, it's not necessarily between the two individuals. It's just a network effect where if they're targeting a non-U.S. person, it's incidentally collecting the data of Americans, more broadly speaking, their communications that they might have had with that non-U.S. person or even somebody that was tangentially related to them. And they have that entire database in their possession that they can then go and query to go and look at, right? But again, they're not having a warrant for it. And I think that this is the issue that comes into play here is that you have the government basically, again, with no kind of real limits on it, being able to just tap into this database whenever it wants. The FISA court warrants that they can do in these limited circumstances that they should be getting. They haven't even done those. So that's why it's like we've been asking over the years, right, for the intelligence community to go and do its job and police itself, but it's proven incapable of doing so, which is why all the reform advocates that got together across the political spectrum were saying, hey, we can't let this program expire because we don't trust the intelligence community to go and do this or respect the fact that it might have expired. And Congress is actually a really important institutional tool for holding the executive branch in check for doing something like this, for that exact kind of fear that you highlighted, where those tools could get used between Americans. If somebody's been designated a terrorist, all of a sudden, maybe, you know, their rights aren't going to get respected as much because they're going to say, hey, we actually don't have to go and respect the Fourth Amendment in this instance.
Yeah,
you're not.
Right. Or if somebody perhaps were classified as an insurrectionist or a terrorist or something, that the government could say, well, that's a threat enough, so let's just go violate their Fourth Amendment rights.
Yeah, exactly. And again, I think the bigger issue is just that becomes a web of like the 7 degrees of insert person here of whose data and whose communications get caught up in that, right? Maybe they go and they do a query on you and you and I are talking. And then, you know, we talk to a whole bunch of different people across the course of any given day or year, right? Now, all of their communications with you got, you know, scooped up. Did you and I have any kind of weird conversation? No, obviously not, right? But yet we're still going to get impacted all the same. Even though I haven't done any crime, there's no reason to suspect that I'm going to do a crime. My rights have been violated for no good reason other than, you know, a suspicion of an individual in question here.
Right. Now, what about the people that support and actually very vigorously defend Section 702? What are their reasons for doing it?
Well, I think that they like to point to the value that the tool creates. As they like to repeatedly point out, over 70% of the president's daily briefing has information contained in it that was ascertained through the Section 702 program. They think that it helps them with their combating the drug war that they have with the cartels. They think that it helps them deal with sexual trafficking, and a whole host of other issues. So they like to go and rely on the value of the tool. And then to your point, earlier in the conversation, they're also worried about, you know, doing anything to that tool that might go and hinder the ability of the intelligence community, more broadly speaking, to carry out its core duties. But they'll go and take it to the other extreme where they say that, you know, you're putting lives at risk here. Or as one representative so colorfully put it during debate, that the country would go dark. And that's just simply not true. But they rely on the value of the program. And this is where I think the reform camp actually kind of had a good buttress against them, because we were simply saying like, hey, we actually know that this program has some value for you if you're the president, if you're the intelligence community, et cetera. We're not trying to take away the tool from you. We recognize the threat that comes with this program sunsetting and getting removed altogether. Some people were advocating for that. But I think in our view, the issue ended up becoming that I don't trust the intelligence community to simply respect that authority is no longer legally there for them to then, you know, not go and do that anymore, because it would just get reshuffled within existing spying programs at the executive branch. So we were saying, hey, let's go and we recognize the value of the tool. We want to go and reauthorize this, but only if we're able to go and get these serious and meaningful reforms to the program.
Right. So one of those reforms, one of the things that was discussed was that if an American's information was caught by using Section 702, that law enforcement would then have to go get a warrant to be able to see or to view that information. What happened with that part of the bill?
Unfortunately, when that particular amendment came up for a vote, ultimately in the floor of the House, it got a vote of 212 to 212, making it a tie vote, which means that the amendment would not be adopted. You needed to have an actual majority, which was really unfortunate. You had Speaker Johnson ultimately cast one of the votes to ultimately go and kill it. And he was a person who was very strong on this issue in past because he served on the Judiciary Committee. He knew. And so that was an unfortunate thing to see happen, but it was a really meaningful vote to go and see so many members of the House go and vote in favor of getting that warrant requirement rule. That is a significant improvement from when this program was last up for reauthorization back in 2017, 2018, when it got that 5-year reauthorization ultimately at the end of the day. So I think that was actually one of the interesting things that we saw kind of play out here is that, yes, the amendment ultimately did not win, but it took all the effort of the administration and the intelligence community, more broadly speaking, to go and make that actually ultimately fail. So that was actually, I think, a pretty big win in its own right, seeing the administration have to go and sweat it out and making calls to members live on the floor as the votes are kind of tallying in. It was really fascinating to see go and play out, but unfortunately, it did not get adopted. So they can still go and tap into American communications, largely speaking, without a warrant.
Yeah. So what is the concern that they express is that if you had to go get a warrant if law enforcement had to go get a warrant to view that information, precious time is lost, and therefore you can have an incident or a terrorist attack or something in between when that data is collected and when the warrant is provided. Is that their argument?
Yeah, that's usually where it goes and stems from, is that the warrant requirement's unworkable, is what they would say. It would needlessly put lives at risk. It would put the United States in a weakened position and make it more susceptible to a terrorist attack. And as I said before, one representative tried describing it, if the program were to go and have stuff like that incorporated into it, of putting the country dark again. And that's just simply untrue. Again, these were very carefully crafted warrant requirements where, again, if you were looking even at metadata, that would have been totally fine for Americans. But like if you were trying to nail down for a specific American, that's when the warrant would have gone and kicked in. Mm-hmm. So we were trying to bend over backwards and meet them at their different concerns at every single turn. But at the end of the day, the intelligence community didn't want to give one iota of an inch on any of this for the reform camp kind of demands. And like I said, the administration and the intelligence community brought it full force to bear ultimately when it came up to the House for a vote. Yeah.
Yeah. And it would seem like we could set up a system, right? Kind of like through the FISA process, which was set up specifically for this, where, you could have a judge just right there. I mean, it could be done very quickly, I would think, to obtain a warrant, right? Couldn't you have that for this very specific case?
Oh, absolutely. I mean, to pretend that it's so hard to get a warrant, it makes me laugh a little bit because we do so much work in the States at AFP too on some of these issues. And I remember when I was living in Utah, there was one study done where the average time it took for a judge to grant a warrant was faster than the average amount of time it would have taken to read the affidavits that were being supplied for said warrant requests. So, that I think goes and kind of undermines the notion that somehow it's really hard and unworkable to get a warrant from the courts these days.
Yeah. How many Americans are getting their information caught up in this Section 702 issue?
Yeah, that's a great question. As I said earlier in the program, in 2021, 2022, those numbers were over 3.4 million total searches of Americans' data in those years. And then they did a little bit of tweaking to the reporting and what they were counting. And the number most recent was something around 230 some odd thousand Americans who had their data get queried underneath the Section 702 program, which is still a lot of people. Again, it's everything from that sitting member of Congress to a local political party to the judge to your sitting member of Congress, et cetera. Like that, it's really bad when that's kind of like where it's coming down to. We think that that's just too many, no matter what. Obviously, the ideal number is 0. To pretend that you're going to get 0 is probably a little foolhardy, but that doesn't mean that we should stop trying to go and hold our government accountable to be better, because the status quo is unacceptable.
Yeah, no question. When will Section 702 be up for a vote again? This has been reauthorized, right?
Correct. So back in April, the House voted to reauthorize Section 702 with some very limited reforms that basically codified internal best practices that the FBI kind of took on. They passed that out, and it's reformed until 2026. So that means that depending on how things go in November, there are a whole host of opportunities, depending on how Congress looks, how the presidency looks, et cetera, where we can hopefully, when 2026 rolls around, have another bite at the apple to actually go and build upon the limited reforms that were done in this most recent reauthorization.
Yeah. So there were some reforms that maybe made it better in your mind?
I mean, we viewed them as insufficient, but basically what I would say is that the reforms, the 56 reforms, as they like to repeatedly go and claim, the proponents of Section 702, they basically were a bunch of miniature things that were put in there to codify internal best practices that the FBI did after Carter Page. Basically, the reason why we don't find these to be overly effective in more often than not instances is that it basically relies on the notion of trust us for the intelligence community. And I'm sorry, but there are decades of data points that we can point to that go and give you so many reasons why that's insufficient. They have proven incapable of respecting the law or the Constitution. And that's why we were pushing for more serious and meaningful reforms, and why we were not supportive of that reauthorization bill that ultimately did go and pass Congress. We wanted to see something more substantive than just trying to artificially limit the number of FBI agents that can go and query the Section 702 database. Is that better? Sure. But does that really go and address some of the underlying concerns of the abuse? No. And also, what happened with this particular reauthorization that was really problematic was that they had amendments in there that would allow for this program to get utilized for vetting immigrants that were coming into the country, that were going to get used for fighting the drug war against the cartels, even though, as we discussed earlier, that's one of their top cited cases as to why 702 is so valuable. And then on top of that, they wanted to expand the definition of what was called an electronic communications service provider. And the way that they wrote it, it was so poorly written that it would have basically captured data centers, a lot of our technology companies that we interact with on social media, et cetera, and basically told them that they all would have to go and help the NSA with its surveillance authorities here. And that was something that was just like a big red line that we couldn't possibly go and support, even if it had those 56 limited. And I really do put emphasis on the limited aspect of those reforms.
Yeah. Well, James, thanks for sharing your knowledge on this, and this is a really important topic, and thanks for your work in doing this. And we have to be vigilant about this. We need to be vigilant about both the national security threats to the United States. That's very important. As you mentioned, you were in New York on September 11th. You know the damage that can be done to our country, but at the same time, damage can be done to our country if we just chuck the Bill of Rights out the door, right? And we don't protect our Fourth Amendment rights as well. So I appreciate you taking the time and being with us today.
Oh, no, thank you for having me, Jeff. It's been a great conversation.
All right, great. Well, listen, thanks for joining us. And this is such an important issue. Your Fourth Amendment rights are important. All of your rights under the Bill of Rights are important and must be protected, must be defended. And, the Fourth Amendment is one of those that everybody wants to always defend the First Amendment rights. We have organizations dedicated to the defense of the First Amendment and the Second Amendment oftentimes. But, when you get to the Fourth Amendment and some of the other rights within the Bill of Rights, they're taken for granted a little bit. So it's great to have James focus on this issue. And again, this is an issue of liberty and of freedom. And we have to defend that at all costs for American citizens. So don't take that for granted. Go out there, defend the Constitution, defend freedom and liberty and the Bill of Rights. And thanks for joining us.
Thank you for listening to American Potential. You may listen to more stories from Americans working every day to expand freedom and opportunity in their communities by visiting AmericanPotential.com.